All right, y'all, one last video for the judiciary, and I'm going to delve into this idea of the judicial conference here today and wrap up the outline. And you'll notice up here, we had been talking a little bit about oral arguments, and we're talking a little bit about some of the circus that goes on with these. The idea that, the justices can interrupt with questions and they can kind of communicate or make arguments with each other through the answers of the attorneys to the questions that they choose to ask. Well, before we get into conference, one other thing that's kind of a big deal to talk about is the idea here of the Solicitor General. And let me, be very clear about this. The Solicitor General is oftentimes considered the 10th Justice on the Supreme Court. Now, y'all may have heard of the Attorney General. The Attorney General is the person that presides over this agency in the White House. But the Solicitor General is actually the attorney that goes before the Supreme Court and argues. And the Solicitor General, as the quote unquote 10th Justice on the Supreme Court, is a position that's kind of interesting because you're really serving two masters. On the one hand, if you're the 10th Justice on the court, unofficially, well, the idea is that your argument should hold more weight as you come before the Supreme Court to make arguments. So if you go in there to win, if you go in there to represent the government, then you should have a better chance of winning because you should have some of the better arguments of any of the counselors that are coming in to argue. With that being said, you've also got to serve your master, the president. And the presidents will oftentimes really push policy through the Supreme Court. Now, if you're a solicitor general and you argue too much with the impact of the president's policy behind you, then odds are you lose credibility as the 10th justice on the court, and theoretically, your arguments will begin to hold less weight. If you try to be the 10th justice on the Supreme Court too much and you don't push the president's policies enough, well, then, golly, y'all, at that point, guess what? The president will be apt to fire you and put somebody else in. So, as I give this to you, the Solicitor General has got a very, very political role balancing the protocol and etiquette of the court versus the politics of the president's policy agenda. Now, if the Solicitor General will argue before the court, they will further divide time. Remember, the timing during oral argument is typically one side gets 30 minutes and the other side gets 30 minutes. Well, if the Solicitor General gets involved, one side will get 20 minutes, the other side will get 20 minutes, and then the Solicitor General will get those other 20 minutes. And that means that if the Solicitor General is arguing on your behalf, you technically now are going to have 40 minutes arguing in front of the Supreme Court on your behalf. If the Solicitor General is against you, then in theory, that means that you are now going to have 2/3 of the arguments before the court arguing against you, which means this is going to theoretically lengthen your odds to win. Now, when you go into conference, and I had mentioned this before, the Supreme Court will typically conference oftentimes on Wednesday and Friday or Thursday and Friday. It really depends on how the court puts together their schedule. And in conference, this is only the justices of the Supreme Court, and they are going to discuss cases. They're going to discuss the cases that have been argued. They're going to vote on these cases. And then ultimately, they are going to assign who is going to write the opinion of the court or the statement of law. Now, understand on this. Seniority is big deal here. And this is reflected in both the order of the discussion and it's reflected in the order of the vote. The Chief Justice, as the first among equals, the Chief Justice will always be the first person to discuss what they feel are the issues of a case. And then it goes from order of seniority, from highest seniority down to lowest seniority. So theoretically, the voices that you will have heard the longest and the voices that you will hear the most will be the people speaking about a case at the beginning. And then by the time, you get down to the more newer members of the court, kind of makes sense that a lot of the things that they would have wanted to have said would have already been said by the more senior members. In theory, maybe in fact, the newer members would be more influenced by things that the more experienced justices said. That's the idea. Now, when it comes to the order of the vote, it's the exact opposite. And the order of the vote is basically the members with least seniority vote first, and then progressively, as you go up the scale of seniority, the members that have been there the longest vote last. Think about sports for a second. Do you want to be the person that starts the game, or do you want to be the person on the court to finish the game? I think you could make an argument that the most important time to play in many sports are the last 4 or 5 minutes versus the first 4 or 5 minutes, because those last 4 or 5 minutes are going to decide it one way or the other. And the logic here is that the newest members of the court are going to cast the votes at the beginning. They're the least important votes. But when a case is 4-3 or 4-4, man, those last two votes, they're the ones that are going to be the most important for the decision of the case. And who votes last? The Chief Justice. And the Chief Justice is always the one that ultimately, in a 4-4 tie, can actually decide a case. So keep that thought in mind. The Chief Justice also has one other power that's very, very important on this. If the Chief Justice is in the majority opinion, then the Chief Justice gets to pick who writes the opinion or the statement of law for the court. If the Chief Justice is not in the majority opinion, then the Chief Justice does not get to pick that, but rather the senior member of the court with the most experience, the longest tenured justice, that person will get to pick who writes the opinion. Now, I give this to you if I'm the Chief Justice of the court and it's 5-3 and I'm getting ready to vote, and I maybe would be the fourth vote, but the 5 has already won. Maybe I would become the sixth vote with the idea in mind that now at least I get to pick who writes the opinion. And if I get to pick who writes the opinion, I may not pick the firebrand, the most radical person, but I may pick somebody that's much, much closer to the middle in terms of writing an opinion. And that will have a big impact on what the court's ultimate statement of law is. Last couple of things here. The least tenured justice or the newest member of the Supreme Court sits by the door. And you will see this a lot in state courts as well, in that they will be the person that answers the door. They will be the person that passes notes back and forth, information back and forth as the doorkeeper. And as they, obviously rise in seniority, they move away from that. But nobody is supposed to be allowed in the discussion room. And that gatekeeper, the least tenured justice, is the only one where you can pass messages in or out, information in or out, sandwiches in or out, this kind of a thing. Now, I had mentioned to you appointments a few minutes ago, and I'll give you something else here, just really, really quick. I mentioned to you the idea of nomination and confirmation. The president will nominate with the advice and the consent of the Senate. Now, when you say advice and consent, this sounds like that the Senate has input on the front end of appointments, like giving the president some names, and then consent on the back end to ultimately approve the nomination of the person that the president has nominated. In reality, y'all, what you'll see is that presidents will typically pick the justices that are going to go to the Supreme Court. Now, are there exceptions? There are. Right now, President Trump has got a Republican majority in the Senate, albeit a modest one. And I bring this up to you because if you think about it, if President Trump had a Democratic majority of senators, then it would be very, very possible that the Senate would have a bigger role in Supreme Court appointments because they control the majority of the chamber. As president, whether you're Republican with a Republican majority, Democrat with Democratic majority, if you want to nominate somebody, odds are that's going to go through unless there's some kind of a scandal, unless there's some kind of a smoking gun. Now, let me say this, and we were talking about John Marshall when we talked about Marbury versus Madison at the very beginning of this. The first video, in fact. And we had talked about the idea that John Marshall failed to deliver the commissions that were on John Adams's desk. And yet he turned into the Supreme Court justice, the Chief Justice, that wrote the opinion for the Supreme Court that decided the case. Golly, y'all, that seems like an incredible conflict of interest. No ifs, ands, or buts. And if you want to talk about this idea of conflicts of interest, I want you to think about the nominations of Merrick Garland and Amy Comey Barrett. If you go back and you look at this, at the end of Barack's at the end of Barack's time in the presidency, and this was, I think, Justice Scalia died roughly over spring break, a little bit before spring break, which would have been about 8 months before the presidential election. And Obama almost immediately nominated Merrick Garland. And this was a big deal because by nominating Merrick Garland to replace Justice Scalia was the fifth conservative vote. Obama nominated a liberal, this would have meant now that the liberals would have had five votes on the court. And this meant that this would have been a dramatic shift in the power. Well, the Republicans, 8 months before the election, said, you know what? No, we're not going to do this. We are close enough to the election. Let's let the American people decide. They never even considered Merrick Garland. And then what happened? Well, President Trump won the election. President Trump nominated a conservative. And in fact, the five votes that the Supreme Court conservatives had prior to Justice Scalia passing, they maintained. The Republicans gambled big. And let's be honest about this. Barack nominated a moderate in Merrick Garland, but he was still liberal. I think you could argue that if Hillary Clinton would have won, maybe she wouldn't have even respected Obama's nomination. Maybe she would have nominated somebody that would have been far more liberal than Merrick Garland. So the Republicans rolled the dice and they won big and they got to keep their conservative majority. Isn't it interesting that you look at Trump and some of the things that he has dealt with. Merrick Garland was named to the Biden administration. Merrick Garland has had a big role in investigating some of the actions of the Trump administration. Now, if John Marshall had a conflict of interest when he did not deliver the commissions, and then he heard the case that dealt with the delivering of the commissions. Doesn't it stand to reason that if the president that appointed somebody for a seat that you had been nominated for and never even been given the opportunity to be heard and interviewed by the Senate, doesn't it sound like it would be a conflict of interest to put Merrick Garland in charge of investigating Trump? It really, really does. And I mentioned to you this idea that people are not liking the Supreme Court as much. They're not liking the legal system as much. Well, this is why, because it looks like business or politics as usual. Now, before it looks like I'm coming down too crazy on the Dems, let me deal with the Republicans. Ruth Bader Ginsburg died very, very close to the 2020 presidential election. And Amy Comey Barrett became the person, in fact, who was nominated, who was confirmed by the United States Supreme Court. Now, remember with Merrick Garland, he had been nominated 8 months prior to the presidential election. Barrett was nominated like 8 days before the presidential election. And Democrats howled about this. Oh, the hypocrisy. You Republicans said 8 months, prior to the election, it was too close. And now we're 8 days away from the election. Can you do this? Republicans came back and said that through the electoral process, the American people had given us the power to make these decisions by putting us in control of the United States Senate. And in fact, Barrett was confirmed. This now was a conservative replacing Ruth Bader Ginsburg, a liberal, which meant now the Republicans basically have 6 seats on the United States Supreme Court, and the liberals have 3. I give this to you. Both parties are working their shenanigans. And Joe Biden, in the aftermath of the election, had actually suggested increasing the membership on the Supreme Court so that he could appoint people. Okay, if Biden did that, who do you think he's going to appoint? Liberals. Is that going to make the politics or the view of the Supreme Court any better? Or would that have made it worse? It would have made it worse. So whether he didn't have the votes or whether they didn't have the political gumption. It never came about for the Democrats to do that, but they have promised vengeance when they get control of the Senate. And while the Republicans might have it right now, that doesn't mean that they're always going to have it. One last thing to think about with appointments, and this is the idea of age. Oftentimes what will happen, y'all, you would think that if somebody had been practicing law for 20 or 30 years, then in fact they would be ideal to become a judge, especially if they've got a really good record, as a lawyer, depending on expertise area, these kinds of things. Well, what actually happens is that they nominate to confirm younger people to be a justice on the federal courts, particularly because that means that when they get to the point where they could be considered for the United States Supreme Court, they're still going to be pretty young. So if I'm looking to get somebody on the federal bench, maybe I'm looking to get somebody in their 40s. If I'm looking to get somebody on the Supreme Court, maybe late 40s, early 50s. So that way, theoretically, they can be there for 20, 25, 30 years. And I give this to you because it's a lifetime appointment. And this means that even a president that only served 4 years, like Joe Biden, could have people that would be on the Supreme Court decades and decades after he's gone. This nomination piece is a really big deal for the presidents. And understand, when Trump had promised that he was going to put pro life judges on the court, he did it not just at the Supreme Court, but he's doing it at the lower court levels as well, which means more conservative justices are moving up the ranks, which in theory maybe would make them better qualified in some instances than some liberal ones, if for no other reason, because they got confirmed and because they had the opportunity to serve. I'll leave it with that. Thank y'all.